want to welcome everybody to this exciting webinar. My name is Ryan Poole. I'm a co-host along with Jim Brown, and we do this bi-weekly webinar to share value with the real estate community here in South Florida. We love doing it. One of Jim's favorite saying is iron sharpens iron, and we have a really great topic this week that's very relevant. Us agents, just so you know a little bit about myself, I've been a real estate agent for over 20 years here in South Florida. Love the industry, love making a positive impact in buyers and sellers' lives and working with other agents. I also launched 2.5 years ago real estate tech company called Realtrade, which is an online marketplace and social media platform for real estate. I implore all you to check that out. Nice thing, it's free for agents. They can create a profile and you can get direct leads right off your listings right on Realtrade. And I'll talk more of that later as we move forward. But I definitely want to introduce Jim. Jim is an amazing person, a quintessential entrepreneur. Not only is he a real estate attorney, he's founder of New Path Title, and he also a founder of an awesome closing software called Title Leap. So Jim, why don't you go ahead and speak here to the audience?
So like Ryan, I've been in this industry my whole life. I've never done anything but real estate. Started out framing houses when I was in college and got my general contractor's license. I was the youngest general contractor in the state of Massachusetts. And then I moved to Florida, got my law degree, and have been practicing and working in the industry ever since. And I was working on the roof of my house on Sunday, and I was thinking to myself, wow, I really am participating in real estate in every aspect of its existence. I'm framing a house, I'm insulating the roof of a house, an old house, and during the day I get to fool around with technology with cool people like Danny and Ryan, and then talk to agents. And when I say iron sharpens iron, I really mean it. Like, you guys call me, you text me 24/7 with your issues you're having in any transaction. I can guarantee you a dozen people in this room have had the same friction. So everything you tell me is actually content that helps us elevate the industry. And our goal is to give you guys content, to give you guys perspectives that you won't hear anyplace else. Everybody can attend a RAPV seminar. Everybody can go to an online lecture. Our goal is to talk about things from a perspective you won't hear anyplace else. And I work hard to find those perspectives and learn those things that you guys, that we can all benefit from, that are unique. So without further ado, and Ryan, I can hear the excitement in your voice when you're doing your intro. I think one of the big first thing I want to say is, before I let Ryan jump in again, first thing I want to say is exhale, right? This is a change in the road. This is not the end of the road. This is a change in the road. A bend in the road is only the end if you fail to make the turn. That's an old bicycle racing colloquialism from when I used to race bicycles. This is not the end of the road, but this is a change, and I think there's tremendous opportunity, and I can see Ryan's like chomping at the bit to tell you guys something about that opportunity he sees. But go ahead, Ryan.
Yeah, no, I definitely want to make this too. I mean, as an agent, I want to make this like a discussion on this one because it's such an important topic.
Yeah.
I want you to ask questions. You can raise your hand. You can put them in the chat as we go. We want to make this a discussion as well for people that have questions. So I definitely want to. I want to share that. But as an agent, been doing this over 20 years, right? Haven't had a big shakeup in the industry like this, since I've been doing it, right? I know they had a big shakeup in the early 90s, so I've been doing it since the late 90s. And as a full-time agent, partners in a brokerage, and this new ruling that came through, right, that now NAR has proposed this settlement of a path forward of how agents are going to operate. And obviously, Jim, you have your outline, the big outlines of this proposed settlement and what it covers. But I definitely want to say, hey, let's get together as agents. Let's share a path forward of ways that we can still work together, right? And honestly, what's our biggest thing here? To put buyers into homes and help sellers get the most value for their homes. So we still want to do that, right? We still want to serve our clients, but what can we do now with this new proposed settlement that comes into effect? So everybody knows it comes into effect in July of this year. So Jim, why don't you start us off with the highlights of the proposal, and then we'll discuss how it affects us agents, and then the different paths forward us agents can do to still serve our clients and help put them in homes and help sell homes.
Yeah, I think Ryan, can you see my screen, Ryan?
Yes. Yeah, I can see
I
it.
think Ryan brings up a really important point, right? and that is agents are necessary. So there's a whole bunch of undercurrents and a ton of shock value, clickbait videos that you're going to find in social media. In 2000, what was the year that SoftBank invested in Compass? 2018? In 2018 or 17, SoftBank is a big investment bank in Japan. They invested billions of dollars in Compass, and they invested billions of dollars in real estate platforms, digital platforms. And they found through their investments that people still want live buyers and sellers. Realtors are not going away. Realtors are a necessary part of the ecosystem. No investment in digital technologies is going to do away with realtors. No change in the law is going to do away with realtors. Realtors are necessary. So what Ryan said earlier was most important in this discussion. These are proposed settlement terms to the Sitzer-Burnett lawsuit, and they apply to a certain class of realtors. So before we get into the details of it, let's go over the class of realtors that it applies to. I usually have a much better prepared outline for this, you guys. Honestly, there's so much here to digest that I was still researching right up until the time we did the show. So I'm going to put this together in a more organized format. There's only a couple of really important bullet points. And what we'd like to do is go over the bullet points and then open the floor up to discussion. So the crux of the issue is, can you see this well, Ryan?
Mm-hmm.
Yeah, I can see it.
All right. So at the crux of the issue, you hear all kinds of misstatements in the popular media, on the news, on the regular television news. I've heard more misstatements of this lawsuit than I've heard factual statements of the lawsuit. So at the heart of the issue, there was two principal things. Buyers, agents, commissions are dictated by sellers. That the Fair Trade Commission, that's a problem. That is an impingement on fair trade, and buyers and sellers didn't know commissions were negotiable. That's the heart of the lawsuit. Everything else, and we all know as agents in the business that those things are fallacies, but that was at the heart of the lawsuit, right? And it was an easy lawsuit for a bunch of jurors to attest to those facts, right? All they know is they paid a bunch of money at this closing. Nobody reads their documents. They didn't know why. So it was an easy lawsuit. You can't blame the plaintiff's attorneys, although I do. You can't blame them for bringing it. It wasn't like they needed a whole bunch of expert testimony and engineering studies and things like that. There's lots of news on the story. There's lots of news misstating the issues. So they're misstating the issue. They're misstating the current rules. And they're even misstating the settlement proposals. And I'll give you a link to the settlement. Nobody wants to read it. It's 108 pages long. I'm going to give you the boilerplate. I'm going to give you the high points of the stuff right now. There's not many changes to the actual rules, right? So a lot of the times in the media, you're hearing proponents state things that already existed. And we can go over them, but it's not really necessary. Most important thing is who is covered and released in the settlement. This is a proposed settlement. It goes into effect hopefully around July, or not hopefully, it's anticipated around July. It's not etched in stone. The judge still has to approve it. Who's covered? NAR and its members, the realtors MLSs, non-realtor MLSs. So realtor is a trademark and you need a realtor designation. So it's non-realtor and non-realtor MLSs. Brokerages with 2022 sales volume under 2 billion. So there are some boutique brokerages in places like Long Island, upscale markets that aren't covered, and they're going to be shouldering a disproportionate burden of the settlement. And we'll go over that in a little bit. And in RAPB and GFLR, either the agent or its brokerage has to be a NAR member to post on the MLS. So I messaged a bunch of agents over the last few days and I said, are you a NAR member? And they said no, but the reality is their brokerage is. So the brokerage or the agent has to be a NAR member to post on the MLS. Ryan, and if I misstate a rule that you're aware of, I want you to chime in, or anybody chime in and say, that's not the way the rule works. But from what I can research, you have to be a NAR member to post on RAPB, GFLR, or your brokerage has to be a NAR member. So I asked a lot of agents if they were NAR members, And they said no, but then I saw that their brokerage was, and so that's how they get to post. Everybody clear on the covered class? There's a tension here because there's a covered class and there's a not covered class. And in a second, I'll go over why that tension exists. So it's 418 million down from 1.8 billion. There was going to be potentially treble damages. So the damages award would be almost 6 billion. But if you fall into the protected class, National Association of Realtors is going to stroke a check for 418 million and you will be protected. So if you're protected, here is what changes for you. Here is how your world changes if you're in the protected class. And there's a question that begs, and we'll go over that in a minute. But if you're in the protected class, selling agents can't require, and again, I apologize for typos and things. This was all done over the last couple of weeks, but it's not last minute, but I was making changes up to the last minute. So selling agents can't require sellers pay buyer's agent compensation. That's no change. We already knew that. You couldn't require it. It doesn't go as far as saying that you have to educate them on the point, but that's the implication, but you can't require it. No change. MLS will no longer publish buyer's compensation or sellers combined compensations. That's a change, right? So we'll go over what I think the fix and what's going to happen, but that is a change. NAR and the MLSs can't create other websites to advertise buyer's agency commissions. However, non-covered class people can advertise buyer's compensation however they want. Full pause, full stop. As a NAR MLS member, the MLS will no longer publish and you will no longer have an opportunity to enter cooperation commissions. Anybody who wants to turn on their camera, you're more than welcome. I'd love it because I can see your reactions and I know whether the stuff I'm telling you guys is resonating or not. But if you're a non-NAR member, if you're a non-MLS member, you can do anything you want to do, but the MLS will not publish it.
So here's the thing that I want to get clear on too. Even if you are a member of the association, Jim, per this settlement, that they have proposed, that you can still publish your buyers brokers cooperation, but just not on the MLS. You can put it on your website. You can put it on other websites, right? So we can speak to that in the future, that you can still publish it other places. You just
I just realized what I put in there was confusing.
Yeah.
However, buyer's compensation advertising is allowed.
Yeah.
So if somebody
so you can still put them on other sites.
Yeah. So if Ryan has a listing at 123 Church Street, I can text Ryan as a buyer's agent, hey, are you offering buyer's compensation? And he can text back yes, and then we can circulate a document between us through DocuSign that stipulates the rates. Those are all
Yeah. I mean, all you have to, which I want to be clear on, Jim, on this, the listing agreement that the listing agent and the seller, enter into if they're offering buyer's agent commission. I mean, all you could have to do is just share that document with the buyer's agent, go, okay, here you're covered. You know what I mean? So that would be a real easy way to facilitate that, because the one part of the MLS, right, which is great, is that commission amount that they're offering to the buyer's agent, that's enforceable once it's put into the MLS. There's a mechanism. Well, that now goes away. So as you're a buyer's agent, okay, you're publishing this on another site that you're offering buyer's agent commission, there has to be something there that they can share with that buyer's agent to know that they're covered, right? So
well, what Ryan's saying is that there's an implicit contract, for lack of a better description, when the buyer's compensation appeared in the MLS. And so now we need to go around, we need to create another vehicle to create that contract. And so as an ad hoc solution, we can absolutely send texts back and forth, and we can absolutely send contracts back and forth and documents back and forth. But I say where there's a vacuum, there's going to be a void, there's going to be technology to fill the void. So platforms like RealTrade, platforms like, I mean, really what just happened is we just created reasons for buyer's agents to go to other platforms.
Yep.
the MLS, the settlement now creates reason. So now it just became a whole lot more valuable, other platforms. But I want to go through this kind of to before we get into
Yeah.
the weeds on one particular element. I want to go through this quickly, or not quickly, but I just want to point it out so everybody understands like the big point. So MLS will no longer publish buyer's compensation or seller's combined compensation. However, buyer's compensation advertising is allowed as texting, email, etc. It just won't be published on the MLS. I changed the layout of the outline a little bit. NAR and the MLSs can't create other websites to advertise buyers, agents, commissions. So NAR can't, and the MLSs can't send data. They can't do any of those things. They have to completely hold up their hands and not be any part of that buyer's compensation discussion. The other biggie is, so that's the first biggie. The other biggie is if you're going to be in the protected class, remember, these are just people in the protected class, written buyer's agency agreements are required.
Mandatory. You must, per the outline of the settlement agreement now, you must, before you show a home, right, if you're going to participate with the MLS and be a member of NAR, you now must have a buyer's, brokerage agreement with the buyers before you even show the house.
And before
That's a
we
big
get
one.
into the nuances of why buyer's agency agreements can or can't be problematic, because there are a whole bunch of discussions on either side of the board, and that's where I want to open it up. There is a form, a North Carolina form that's been discussed pretty heavily as being a form that they like, and we'll go over that in a minute. But I can see the opportunities and the disadvantages in the buyer's agency form for sure. But just understand, if you're going to be in the protected class, this is how you have to behave. Buyer's agents can't make more than the fee contained in the buyer's agency agreement. So they've put in the settlement, the elimination of hanky-panky clause. There's no levering the buyer at the last minute. And I'm not saying anybody on this podcast would ever do that, but there are people I've seen lever their clients at the last minute in a transaction into situations that aren't necessarily comfortable. So that's in the
So
stipulation.
basically, too, what that's saying, Jim, is okay, you can't have a buyer's brokerage agreement where the buyer pays you and then also get compensated from the seller as well.
Okay.
That's my
I hadn't even thought of that. Yeah.
Yeah, that's my understanding from that part of the
When I read that provision, you guys, and this is all cutting edge stuff, right? This is all coming down and being discussed within the last 5 or 6 days. My understanding of reading it was you can't tell the buyer you're charging X and then at the last minute say you need more to cover it. That's implicit. If you're saying that they can't make an additional fee from the seller's side,
and the buyer pay you too. That's my understanding, Jim, from what
I'd
I've
have to research that further. I don't want to say yes or no. This is an old rule, right? This is nothing new, but this is part of the settlement. Realtors must disclose to buyers and sellers commissions are not a standard rate and are negotiable. That's nothing new.
Yeah.
And there are some listing agreements throughout the country that I saw where that's a prominent disclosure in the listing agreement. Realtors are optional. Commissions are optional or negotiable, and you don't have to pay a buyer's agent fee. We don't have that in Florida. I suggested that if we had done that in 2018, we might have been avoiding this altogether. It doesn't really matter at this point. It's already a rule, but it was stipulated in the settlement. And then this has already been a rule since the Department of Justice settlement of 2019. Buyer's agents can't say buyers don't pay commissions. And buyer's agents can't steer buyers to higher commission properties. That's all been long established, but that's back in the settlement agreement.
What about the buyers steering the buyer's agents to properties that offer seller commissions, to the buyer's agents so they don't have to pay Jim? What about that?
Here's a really interesting dynamic, and this is where I wanted to open it up to the floor. I wanted to start talking about some of the winners and the losers for a minute in this settlement. So that's the high points, you guys. There's 108 pages. There's only about half a dozen pages of really substantive stuff that affect us. you're likely to have 3 conversations with your client. If you're a listing agent, your relationship with your client is probably going to have 3 conversations where it used to only have 1. Your first conversation is, what will you pay for me to list the property? Pretty straightforward. I'm imagining a seller's going to say, what do you usually make, or something like that, and you'll have to give them some kind of a scenario. 6% has been the norm, and I usually make 3% of the 6. That's by custom, it's not by law or rule. And then the second conversation is, what are you willing to pay a buyer's agent? And they're going to ask you questions, probably historically, on how that's come down, and so you're going to have to disclose that. And then the third conversation you're going to have is, what are you going to pay me if I get both sides? Now, the listing form is going to change in substance, I would imagine. I can't imagine it's not. But those are going to be your 3 principal discussions. Anybody have any questions about that? They're just going to be separate discussions. What are you going to pay me? What are you willing to pay a buyer's agent? You don't have to pay them anything. And what are you going to pay me if I get both sides? And we'll go over in a minute why I think these discussions, this last discussion, is going to be more relevant. But this is really where I want you guys to give me some input. These are just some more notes that I was collecting. I think it's a huge fallacy that prices are going to come down. When was the last time you saw anybody that found that their cost of selling was going to go down, lower their prices in any market, in any industry? You know, when you go to here's one big problem I have with the settlement, and I've brought it up a few times. If you go to a surgeon's trade commission association meeting, the whole discussion is around, how do I make more money by simpler procedures, by less expensive equipment, it's all about making more money. You don't leave the trade show and go back and charge your clients less money, your patients less money, because you just learned of a lower cost procedure. And I don't imagine sellers are going to do anything any different. So the whole discussion you hear about prices coming down, in my opinion, that's a fallacy.
I mean, I've never seen a point, right, where the sellers are going to want to make less money. They're going to make as much money as they can, right? So, I mean, who's going to get it at the end of the day? Would it end up being the seller, right?
Yeah. So I want to go over the winners and the losers, and then some points of conflict, because I want to get you guys thinking about stuff, and then I want to open the floor. We're 22 minutes into it. The winners, the non-MLS platforms. Instant winner. Buyers agents are going to be driven to these things. If you're a member of a brokerage that has a good online presence, it's a great opportunity for you to advertise cooperation commissions. I think that's the big winner right there. Here are the points of confusion and the losers. If you leave, this is something that I'm still reconciling.
Yeah.
If you leave the protected class to operate a certain way, now you have to be exposed to the settlement, right? So that's a problem. And this is something that I thought up on my own. I haven't heard anybody talk about it, but there's a protected class. And if you decide you don't want to be part of the protected class, then you have to figure out, how you're going to manage the exposures. Here's
Let me
another.
ask you this question, Jim. Have you seen like a timeline? Like how long is this, this settlement are you protected by? And then after a certain point, you know, does it drop off then everybody leaves NAR? I mean, that could happen, right?
That's one of the things that we have to figure out as time goes on. If you're a
Yeah.
NAR member today, are you protected? And you're not a NAR member tomorrow, are you not protected? These are all things that have to be hashed out. This is an early iteration of the agreement. The thing we know for sure is, as it's proposed today, there won't be compensation commissions on the MLS, and you have to get buyer agency agreements if you want to be in the protected class. Not that complicated, but here's some of the issues that I see. Confused buyers. So here's the losers. Confused buyers not having agents because sellers aren't paying, right? So what's the natural correlation? We all know what that means. The winners would then be more double dips.
Well, you bring up a valid point. Let's say that the listing agent isn't offering buyer's agent cooperation. They're just say their listing agreement is for 3%, and I'm going to sell you the home at 3%. Would they not now, if they want to double dip and get paid for representing the buyer as a transaction broker, they would have to get a commission agreement with the seller, right?
That is the most, what you're about to say, Ryan, is the thing that excites me the most.
Yeah,
But it's also a point of conflict.
yeah.
So I outlined that right here where it says, all right, so buyers canceling late. Here's another loser. Buyers canceling late in the game because they've run out of money, or they realize, they realize late in the game, oh, now I've got to pay something out of my side to get this thing closed, right? So if you have one of these, what I call doctor's agreement, buyer's agency agreements. So in a doctor's agreement, you walk into the medical center and they say, if your insurance doesn't cover all of this, you agree to cover the remaining portion, right? Everybody signs that when you go to the doctor's office nowadays. It's become standard practice. I can imagine a buyer's agency agreement that says, if the seller doesn't cover all of it, you agree to cover a portion, Mr. Buyer, Mrs. Buyer. But what happens legitimately if they get to the end of the transaction and they can't pay? And they didn't realize they were going to have a burden, and the seller's agent and the buyer's agent didn't disclose it to them that they had a piece. And then they get the settlement statement and they're like, where are we going to come up with this money? We've all seen it before on the seller side. You get a deal that's skinny, and then you get to the table, and then all of a sudden there's something like a prepayment penalty in a mortgage, and the seller who was getting skinny proceeds at the sale now is getting nothing, or sometimes they're upside down. I had a seller bring $110,000 to the closing table the other day. It was a high net worth seller, but I'm just saying, we've all seen the skinny deals that get skinnier and the sellers protest. What's going to happen when that happens on the buyer side? It's a rhetorical question, but it's absolutely something that we're going to face. The buyer didn't know until the last minute that they got the settlement statement that they had some piece of the burden. And that's a result of what I call these doctor's insurance type buyer agency agreements. That's a term I coined. You heard it here first. But you know what I'm talking about. If anybody doesn't understand, raise their hand or jump into the chat. But we've all done that at the doctor's office, and I would imagine that's the way buyers agency agreements are going to go. Now, here's the conflicts that I see and the tensions that I see. So if you're in the covered class, you can't do these things. So if you want to go and do these things, you have to be in the uncovered class. I have to figure out more of the time frames when those kick in and when they don't. Here's the one that Ryan was alluding to that I am so torn and conflicted over. Selling agents will get more double dips when they pick up buyers who don't want to pay buyer's agent compensation because their sellers don't pay buyer's agent compensation. So now you're in this conundrum, right? So selling agents will be incentivized to have their sellers not pay buyer's agent commissions so they can be more likely to get the double dip. But the buyers will have to find these properties without buyer's agents. Is everybody with me?
Yep.
So now you're having the conversation with your seller at the onset, and you're hoping your seller doesn't say that they want to pay buyer's compensation so that you can get more opportunity for the double dip. But now you don't have the incentive that you used to have for buyer's agents driving their buyer's agents to the properties. This is the inherent conflict. I haven't heard anybody talking about it anywhere. And if anybody thinks that I'm not seeing this accurately, absolutely speak up. I want to hear your perspective. And what if buyers already signed and had a buyer's agency agreement and don't have the money to close? We talked about that in a second. What happens to the buyer's agent? What happens to the transaction? You know, all the obvious applies. And then the other big conflict that I see, and I've only heard one discussion on this, is brokerages that have over 2 billion in sales will have a huge and disproportionate settlement burden. And I think these shops will likely step up and cause settlement problems. And it amounts to about 50 or 80 shops. So what happened was, we talked about it at the beginning of the show, there was this potential pool of settlement of about 6 billion after the triple damages on the 1.6 verdict. And if you're not with me, just somebody speak up. And so what they did was they said, if you're in the protected class, NAR is going to stroke a check for 418 million. Well, half of 418 million for all intents and purposes is $500 million. So 6 billion less $500 million still leaves 5.5 billion they got to get from somewhere. And when you start seeing the numbers that are going to be placed along these brokerages that aren't in the covered class, they're gonna step up and say, wait a minute, we weren't even part of this negotiation, and now we're being tagged with this burden. I feel like, and I don't want to get shot down for this, I'm gonna have to check my car for bombs underneath the floor of the car later. I feel like NAR threw these big shops under the bus so they could get this reduced settlement, and the big shops are gonna step up. So if you had a dollar less than 2 billion in sales, you're a covered shop. There's a good shop, there's an example of a shop in Long Island that had over 2 billion in gross sales, like $2,050,000. And now they're in the uncovered class, and their obligation under the settlement was like 400 million. It was almost as big as the protected class. I don't want to throw out the number for the shop in Long Island, but it was a big number. It was, I want to say it was several hundred mil. It was a couple hundred million. It was a big number. And so if I were in that unprotected class and I had a disproportionate burden, the first thing I'd say is I didn't have a seat at the table when we were negotiating this thing, and now I have this liability. Again, I haven't heard any but one discussion over this topic, but I haven't, but it's not part of the normal dialogue, but I can see this being a monkey wrench in the potential settlement. So now that I've shown you guys all my cards and I've given you my opinions, I'd love to hear what you guys have to say about this. Do we have anything in the chat, Ryan?
Not yet, but I'll give like a quick overview of what I see that could happen, right? I mean, it's obviously still early now. I want everybody to know this is a proposal that still needs to be approved, right, by a judge, correct, Jim? I mean, you're the legal expert here, right? This still has to be approved. So could there be changes to this proposal before July?
Yeah. There's going to be changes. They're not going to be from the attorneys that I've heard representing the major brokerages. They don't expect that the changes are going to be on those two principal points. Compensation, but cooperation compensation won't be published in the MLS, and you have to have a buyer's agreement if you're going to be a NAR member and participate under the rules of NAR imposed to the MLS. So those two issues, with a high degree of certainty, will be in the final settlement. The issue that I can see taking longer to ratify the final settlement is this light switch at $2 billion, whether you're liable or whether you're not. If you're a big brokerage, there are 50 to 80 boutique brokerages that are going to make up the bulk of that. So the bulk of that initial proposed settlement. So I can see that they would come to the table and say, we got to discuss this further.
Yeah. One thing, that I want to say, one of the largest core functions of the MLS now has gone away, right? With the cooperation agreement. One of my favorite sayings is real estate. I heard this from another real estate agent. If it doesn't make dollars, it doesn't make sense, right? So, now for agents, one of our biggest value propositions for joining the MLS is buyers, especially as buyers agents, is, hey, that we know that we're going to get paid on this deal, right? That I'm looking at properties to share with my clients and show them that I know I'm going to get paid. And it's going to be really interesting to see, what happens, and also I think the biggest thing here is, making it mandatory for the buyers, to have a buyer's, agreement with, commission agreement with the buyers. You're supposed to do it before you even show a house.
Yeah.
So what if it's like the first time meeting a client at a house, you got an online lead, right? From online, you haven't built rapport, they want to see a house, you go and you want to show this house, but technically you're supposed to before you even show it, you're supposed to have this buyer agency agreement filled out and signed before you even sign a house. And how are they going to enforce that? And
Well, Ryan, help me out with this logic, right? So to post to the MLS, you have to be a NAR member, an RIPB, GFLR, you have to be a NAR member. And so if you're going to post to the MLS, you got to fall under the jurisdiction of the settlement. And if you fall under the jurisdiction of the settlement, you got to get a buyer's agency agreement. Am I seeing something wrong? If you're going to post to the MLS in Palm Beach County, you got to get a buyer's agency agreement moving forward, right? So here's a buyer's agency agreement that the legal world and the pundits in this space are saying represents a pretty good outline of what they think a future buyer's agency agreement will look like moving forward. We have buyer's agency agreements in our forms. They're a little different than this. It's absolutely going to change. This has got the standard. Are you going to be my exclusive agent or a non-exclusive agent? There's a period in here, which is just like if everybody's not familiar, there's a clause in the MLS that says that if your listing agreement expires and the seller sells, you can, there's a protection period, but there's a unless clause in the protection period that undermines realtors. We can go over that again if you guys want, but that totally cuts off your commission from the protection clause. In this thing, it's very interesting that they replaced the unless clause. Can you see what I highlighted? In good faith.
Yeah.
Can you see that, Ryan? In good faith?
Yeah, I do.
So the way our MLS, I want to digress just for a minute because this is an important point, and I've heard agents tell me, oh, that'll never happen, and now I'm seeing it happen more and more. Under conventional listing agreement, we're talking about the regular seller listing agreement. If your listing agreement ends, and during the period of your listing agreement, you showed a property to Sally, the buyer, right? And then at the end of the listing agreement, Sally ends up closing, you would be protected under the protection clause, right? You following me, Ryan?
Yeah,
So
I'm following you, Jim.
you would be entitled if it was within whatever you stipulated, 90 days, Sally closes after the expiration of your listing agreement, that seller owes you a commission. Unless the seller relists. So what are sellers now doing? We talked about this in an earlier show. They're making life miserable for the selling agents. They're killing the contracts. They're going out and getting a flat fee listing service. And then they're closing with Sally and cutting off the realtor. I never would have told you. What's that?
No, I mean, I could take a contrarian approach here where this actually empowers the buyer's agent, right? Well, maybe the flat fee brokerage is now like, hey, the quickest way to sell my house now isn't paying just the listing agent the 3%, and then we negotiate with the buyers at every transaction for their commission, right? Is, I list this on a flat fee and I offer a good buyer's agent's commission. It could be a whole contrarian approach to this, Jim, of what,
Yeah.
the market shakes out. We don't know exactly what's going to happen, but you bring up a very valid point here.
The thing I wanted to point out here is in this buyer's agency agreement, they did away with the unless clause and they replaced it with in good faith. So if you have a buyer, and they should do this in the listing in the listing agreement in Palm Beach County, if you have somebody that terminates your listing agreement and goes out and hires a flat fee agent, you can't avoid the commission to the original agent. That's why they stuck in good faith there. If you're not operating in good faith, you can't dodge that issue. So this is, again, this is a buyer's agency agreement that people are saying is a pretty good form, a lot of discussion about it. The listed property, here's the events of compensation, unlisted property, theoretically it would be the same commission, but maybe you take a little more commission for an unlisted property. Here's the part I like the best. Can you see that, Ryan?
Yep.
I don't know if I'm able to blow this up anymore. No, this form can't be blown up.
I can see it. I can see it clear, Jim.
So I'm going to throw this out there because I've had this discussion with a bunch of different agents over the last several months. Retainer fees. I'm not suggesting that you go out and get a retainer fee. I'm just saying it's something to think about. And it doesn't have to be the entire commission that you think you're going to get paid. But if you're going to go out and get buyer's agency agreements, I've talked to a number of realtors, particularly ones that work in the higher market segments, and they say, give me $1,000, give me $500. That's my retainer. It keeps everybody honest and it cuts off the conversation early.
Yeah.
Again, I'm not saying you do it or you don't do it. I'm saying I've heard a lot of people do it. It sounds intriguing to me. I can also see how it would make buyers run the other way, but I'm just throwing it out there as a tool I'm hearing realtors use and
Hey,
successfully.
we got a couple quick questions here. Marina Fink asks, not sure how we possibly schedule tons of showings when each one will take days to get signed off when seller's out of town. So this, Marina, from my understanding, let's say the listing agent on his listing agreement with the seller doesn't offer any kind of buyer's, agent commission, right? Now, if they are offering a buyer's agent commission, you as a buyer's agent wouldn't be protected. They could advertise on their site or on RealTrade or on other sites that they're
Realtrade is
offering.
the best place to put
You can
that.
search that out. Yeah, you can search that out and find out, and then you know you're protected. You could even ask the listing agent, hey, can you send me a copy of your listing agreement so I know that I'm protected? That's what I would do, right? If I'm especially getting in, if the buyers really like the property, I would definitely want to see that before I made an offer. Because now
Well,
the mechanism MLS,
you're gonna want something in writing, not necessarily what the seller and the selling agent sign between them. We're gonna come up with a form. Technology's gonna fill this.
this is, yeah, so there's
Yeah,
going to be a commission agreement form.
yeah,
So this is where I
exactly.
wanted to say with Marina is like, okay, if they're not offering it, okay, and you still want to go after this, get the seller to pay your commission as the buyer's agent, you are right. You're going to have to get a commission agreement from the seller that they're going to pay you, the buyer's agent, commission on the deal, which is a, you know, a huge step. I think there's going to be technology that can facilitate that and make it a pretty easy situation. But that's, yeah, it's going to be a lot of work. You know, if they're not offering that buyer's agent commission, it's going to be interesting come July to see the listing agents of how many offer buyer's agents commissions.
Ryan, read her question one more time, though. I want to make sure we addressed it.
Okay, she goes, I'm not sure how we can possibly schedule tons of showings when each one will take days to get signed off when sellers are out
No
on it,
more bagels.
you know,
So
and those kind of things.
I think
So
she
yeah,
says signed off. You think she's at, I'm not sure if she can hear, if she can chime in. Who was the question from?
that was from Marina. Marina, do you want
Rena,
to
if you
chime
wanna,
in for some clarity?
yeah, make sure we answered your question. That's all right if you don't want to. So there's two things. There's like, in my mind, they're not paying a commission, and so now you got to have the difficult but if you're already showing the buyer's agent and you're a NAR member, you already have your compensation agreement signed. So theoretically, you did that up front, and then the additional pain would be figuring out if the seller's going to pay a buyer's cooperation. So the first step is you're showing buyers, you got the agreement signed. That's a hurdle. The second step is you found a property, and is the seller paying cooperation commissions? I think that the second step through a platform like RealTrade, the exchange of digital information, it's going to be another little hurdle, but it's not going to be a big hurdle.
Yeah.
I mean, certainly, Ryan, I would imagine you guys are going to start some kind of technology.
Yeah, we actually already have it built, Jim, with the live listing update. You could just go on a Realtrade. There's over 2,200 agents on now. They're active. A lot of listing agents that are on there. They can give a live listing update and say, "Hey, I'm offering this much commission to the buyer's agent." It literally gets attached to the listing, right? You can then you could DM the listing agent, "Hey, can you share the listing agreement so I know I'm protected?" You could do that, you know, right on Realtrade now. So we've already have that in place, Jim, which is something that's really exciting. So as you mentioned earlier, I think technology
Yeah.
is going to solve this problem. But if I'm a listing agent, I'm not cutting out the buyer's agents. Even if I was listing my own house for sale, I'm going to offer, you know, buyer's agents commissions, right? I mean, it's incredible. Like I can't imagine a world where, you know, as a listing agent myself, and I list properties where I'm going to go to my seller and go, "Hey seller, I'm going to exclude 1 million people that could possibly, you know, sell your property." All these agents, or hundreds of thousands of agents in Florida from selling your property. I would say, hey, let's offer a
Well, I
buyer's
think
agent.
you bring up a really good point, and and 2 points that come to mind on that issue. I just sold a house recently. A realtor showed me a beautiful house to buy. I fixed it up and I gave it back to the agent to resell. I paid cooperation commissions. I was a seller. I want to make sure I'm getting all the traffic to the property I can get. And then another good point is that's a real life example is Seattle. Seattle's had this rule in place for years, and they've advertised the rule in place for years. Sellers are still paying buyers cooperation commissions. It hasn't, I saw some stats on it the other day. It hasn't diminished the buyer's compensation values appreciably at all.
Yeah.
Um,
So Jeff Stewart has a question. If the original listing does not include compensation for the buyer's agent, can the seller give a credit to compensate the buyer's agent? And does that affect the max seller credit the buyers might receive?
Say it one more time.
if the original listing does not include compensation
Yeah.
for the buyer's agent, can the seller give a credit to compensate the buyer's agent and does not affect the max seller credit the buyer might receive? So I can speak to this one, Jim, from my reading is you can put the seller can still, like they can now, offer a buyer credit, right, at closing to help cover closing costs. That doesn't change. That still stays there. But it explicitly says in the settlement agreement that you can't mention that the concession that the seller's giving the buyer covers the buyer's agent commission. Like you can't, that's not a workaround, that the MLS will help facilitate. So yeah, that's my understanding on that, Jim.
Well, that's a good point, Jeff, and that is, if you were to put in the contract that the seller is offering a credit to buyer of $10,000 and you don't stipulate what it's for, is there a problem? Not necessarily. I can't see that there would be a problem. Now, it could be a seller's credit to buyer for anything they want, including commissions, but the heart of the settlement as it stands now is it can't be advertised on the MLS. So however you want to get your credit into the buyer's hands, I mean, I don't even know that it would be a violation to say that it's going to be, I'd have to think about it a little bit, but I don't see why it'd be a violation to say it's for buyer's agent commissions.
I guess what I was asking about, Jim,
Yeah.
is, certain loans have max seller credits, whether it's 3%, 6%, whatever that is. I didn't know if this would be handled like as an addendum to the real estate contract, or would it go through the seller's credit scenario? And that would be only in regards to, obviously finance properties, but.
I mean, I think that the biggest issue, the biggest uphill is going to be from lenders on that issue, but I don't think it's a violation of the proposed settlement the way it stands right now.
Yeah. This,
Let's just imagine a scenario where you had a seller who didn't want to pay buyer's compensation. And I'm thinking out loud right now. Let's say you have a seller who doesn't want to pay buyer's compensation. And it says, you go on Real Trade and it says the seller's not paying anything. Why can't a seller at the last minute say they're going to give a $10,000 credit? Why can't they? To make the deal happen.
but it would still have to be, there would still have to be some kind of agreement that the
Is that handled through like an addendum for the real estate contract that addresses that?
I can imagine seeing something in the contract in paragraph 20 or a successive addendum that says sellers paying a $10,000 credit to buyer for buyer's realtor's commission. Now, the lender is going to have the biggest uphill with that potentially, but I don't see why that would be unlawful. Now, and then that scenario again would be the seller that doesn't want to pay cooperation commissions at some point in the transaction to make this transaction occur. They're now going to step up and pay those things to keep the transaction alive. I can see it happening. And there's all kinds of crazy scenarios we can imagine, like contingent fee contracts, and not contingent fee, but contingent sale contracts. And then there's the step up clause, right? I mean, this thing can really get confusing, like step up clause.
I mean, the buyers now, agents now as a buyer's agent, not only do we need to negotiate the price, right, for our buyers, right, and do all that legwork, right, and sell the home. Now we have to be really good negotiators to try and get the seller to pay our commission. I mean, that would be like you're working on behalf of the buyer, right?
Losing ends of the same contracts, kind of sort of.
Yeah,
negotiating with your client and negotiating with the other client.
But
that's what I'm saying.
Here's the inherent problem I have with that. And I think that the settlement overlooks a couple of different things. The first problem I have is now you're a buyer's agent negotiating with your buyer, and you're negotiating with the seller. Well, any negotiation you do with that seller absolutely hurts your buyer, even if it doesn't hurt your buyer on paper. Do you know what I'm saying? So now you're going to the seller and saying, hey, give me some money. That absolutely muddies the path that the buyer has to walk down, even if the settlement would say it doesn't. You know what I mean? And so that's an inherent problem. The other problem that I have is I guess they just wanted to take the legs out from underneath the MLS. But if I've lost my dog, and I brought this up before, if I've lost my dog and I want to post on every single light pole around my house, $100 reward for anybody who knows anything about my dog, why should that be a problem? Even if they don't have my dog? Why should why should a judge be saying, I can't do that? Why is a judge saying that we can't put buyer's cooperation commissions in the MLS, but we can put it every place else? I don't think it's the end of the road for us. I'm just saying there are definitely some inherent problems. There's no
I mean,
perfect solution here.
it's really, they're trying to break up the trade association of NAR is what I'm seeing, right? I
Yeah.
mean, that's the biggest thing, and it could fracture, right? I mean, it could. I mean, NAR, later on down the road could go away, and there could be something else that moves in its place. Maybe it's just a loose, affiliation, right? That agents have moving forward, that we offer, we
I,
work on a system, together, and there's no rules or regulations as far as trade, right? That we're cooperating. It's like it's in a case by case
it's
basis
all
with
going to
each city.
boil down to written agreements and digital technologies.
Yeah, I know.
The
No, I
great
definitely see.
The great
Yeah, from
agents
what I
aren't going away. Good agents aren't going away. The agents that weren't
know.
making it before, they might have some uphill or they might see this as a problem. A new agent certainly getting into the business, to them, this is
Mhm.
just going to be, this is how it is. This is what we got to do. There's no new agent that's going to go like, we're not doing this. They're going to be like, here's the rules of engagement. Let's play, game on.
Yep.
And we got to
Yep.
continually approach this thing with new agent eyes because that's the way the game is. It's an evolving game. To say we want it,
Yeah.
we're not going to participate unless it's going to be like it was. You're going to be sitting out. Everything's
I mean,
changing.
the nice thing is, like, it's a market, it's a market out there, right? So what's going to happen is, like, what are the properties that are going to sell? Well, to this point, the properties sold are offer buyers agents commissions, right? So all of a sudden, if a lot of these listing agreements don't offer that, and are the properties don't sell. I mean, what's going to happen? I mean, they're going to go back to offering buyers agents commissions, right? And that's the ones that sell, because the reality is most buyers are represented by a buyer's agent, right? I don't see that going away. So, I think that's what's going to, it's going to take some time to work through, but I think at the end of the day, the market's going to dictate of what works best. And what I do see, Jim, is I see, number one is the listing agents that offer the buyer's agent commission are the ones that are going to sell homes quicker, right? There's going to be sites that they can advertise on that going to
There's
drive
plenty of
more
examples of that.
traffic. And then
Yep.
another thing, if they don't offer it, what I do see happen is these commission agreements for the buyer's agents to get paid by the sellers. Like, and it's just a negotiation every single time with every single property that you're going to try negotiate as the buyer's agent with the seller to get paid at closing.
And I
I
want
mean,
to, and I
that's
want to go back to that inherent tension about what I brought up earlier. So now you're a selling agent having the listing conversation with your seller, right? You want to get your commission. So you want lots of buyer's agents to be driven to that seller because the seller is operating cooperation commissions. But if the seller says no, there's also an opportunity for you to double dip. You're going to have to go out and hustle a little more to find buyer's agents, but now you get the double dip. So it's going to be
yeah.
interesting to see the way this shakes out. You know,
But they're still going to get, I mean, to double dip, if they don't on their listing agreement, it's just between them and the seller, they're still going to have to get a commission agreement for the buyer, Jim. Like, they're still going to have to go out and say, hey, if I want more percentage than the 3% we agreed that I'm going to sell your house, and I bring the buyer, right? They're still going to have to be in a separate agreement between the seller for that buyer,
no, I agree
right?
with that, where the buyer has an
Yeah.
agent. What I'm thinking
No, I
is,
mean, where the buyer doesn't have an agent, Jim, they come directly to the
yeah,
listing agent. The listing agent isn't offering buyer's agent cooperation, so
yeah.
there's nothing stated. They're going to have to get another separate agreement when they do that from the seller, and the seller be like, "No, I'm paying you 3% to close this deal." Like, they
No,
could say that.
what I'm saying is at the onset, when you go for the listing appointment, Ryan has 3 conversations with the seller. First one is how much you're
Mhm.
going to pay me. Second one is how much you're going to pay in cooperation. Third one is how much you're going to pay me if I double dip. So you'd
Yep.
have, in my opinion, as a selling agent, you'd have that ironed out at the onset. So if you get what I call
Yeah, that they
naked
pay you
buyers,
those. So then, but why don't they say, well, then why don't I just offer that same commission to the buyer's agent that I would offer you to if you bring a buyer,
well,
right?
that's why I wanted to
I
open
mean, like,
that
right? I mean, it's just like,
discussion.
what if I'm going to pay you to bring a buyer? Why am I handcuffing myself now and not offering that same commission? My point is, I don't think the sellers will sign that agreement. You're gonna have to get, as a listing agent, if you're only doing it for 3% and say I'm gonna sell it, but you bring the buyers, you're gonna have to then try finagle a commission agreement for that buyer, Jim. Like, I mean, that's what I'm saying. People haven't thought all this through. There's a lot of layers that go into it.
Well, that's why I wanted to open this up for discussion, but we're getting a lot of timid agents that don't want to give their
Oh, we
opinion.
do have a great question here from Doreen. She asks, my brokerage suggested that the use of the clause seller to credit buyer XXX at closing of escrow to satisfy buyer's contractual agreement with the buyer's broker, as is currently used in VA and FHA loans to satisfy underwriting. Yeah, but I mean, the lenders, as Alan points out, how does that value then the appraisal, right? Could be problematic and significant. Yeah.
So now you got a pumped
Because
up.
basically they're saying, yeah, if they're putting that in there as a seller credit, like now, how does that affect the appraisal if it's a loan? That's a very valid point that Alan, points out.
Yeah.
My opinion is, guys, this is my opinion of doing this and being in the trenches with you all is, man, try find out if the listing agents offer a cooperation agreement first, right? That's going to be your easiest route, right? But if they're not, and you can't find that out, man, get that commission agreement, push to get that commission agreement from the seller. You know what I mean? Because it's not going to affect the appraised value. It's going to be in writing. You're going to know you're protected. I mean, that's my opinion, what I think is going to, happen. And if they don't sign that commission agreement, then you have that agreement that you sign, the buyer's agency agreement, then that the buyers are going to pay you. Wow. All right, Doreen, you have.
Yes, Ryan, it actually doesn't affect the appraisal because it's not a concession of the property. I mean, we use this clause in the foreclosure market very effectively, and it didn't affect the appraisals because the credit isn't for the property, it's to an entity, the brokerage. So
Yeah, I guess it would depend. I mean, we have Jeff Stewart here, a lender on the call. I mean, how do you see that, Jeff, as a lender perspective?
I know it clears underwriting.
Okay.
I don't. Well, it's not supposed to affect the appraisal one way or the other. To be honest with you, I mean, it shouldn't. But I don't think it. I don't think it's going to affect it one way or the other personally. But
Yeah.
Right.
If the property doesn't appraise, the property doesn't appraise. If the purchase price is pumped up for this credit, then
Well,
it's going to cause.
Well, I was just speaking specific to the credit, that someone had put in the chat that the credit would affect the appraisal, because the appraisers ask us if there's seller's concessions. But in the sense that this is not a concession for the property, we're not. So I'll give you the example: a concession to change out carpeting of $5,000. Well, this would be a credit to the buyer's brokerage. It has actually nothing to do with the property, but I believe the law requires it needs to be on the altar. So it satisfies both things.
I mean, we all agree that you can include credits without a label as to what the credit's for, right? I see a lot of agents in their addendums, they'll say, but before we talk about lending or non-lending, I'm just saying, as a general statement, you guys, we all agree, when you put in a credit in there, let's just say that the electrical supply box is too small, and so the seller's paying a $5,000 credit to up the amp service to the house. You can just say in the addendum that there's a $5,000 credit, seller's paying, right? You don't have to list what it's for. And so what I think the thing that Doreen is saying, if you put some type of a description on it, it can help with loan underwriting.
Right, because usually if the underwriters see an addendum of credit, they usually ask, what is it for?
Yeah.
So,
I'm
and
going to beat them to the punch and just say it's for commissions. It's not for
exactly. And this would actually be a clause within the contract. So it's, as I understood it, they're not actually, it's going to be added to our contracts, and it'll either be you know, filled in or not. So it's not going to be a separate addendum at all. Because I was under the impression that sellers no longer can offer a buyer's agent commission.
No.
No,
Sellers
that's
can
not-
offer buyer's agent commissions. The two big takeaways,
It
the
just
buyer's
can't be
agent-
advertised on the MLS.
Yeah.
Okay.
and buyer's agency agreements. When you boil it all down, right, those are the two biggies. Buyer's agency agreements, if you're going to advertise on the MLS, if you're going to be a member of NAR, if you're going to post to the MLS, buyer's agency agreements, and no offers of compensation on the MLS. Those are the two big takeaways. Everything else is opportunity. Opportunity for you to distinguish yourself and operate more efficiently using technology to figure those things out instead of the MLS. But if you work for a company like Compass or Keller or whatever, and you have your own IDX feed site, you would want your broker to make sure those things are listed on the site so that so people are being driven to your site. Buyer's agents are being driven to your site. Buyer's agents are seeing other properties. That's the value of real trade. Create a platform where all that knowledge can transfer seamlessly.
So Ronald has one thing. Has a question. How does this affect listings currently active? Are we required to contact the seller and disclose and give them the opportunity to negotiate?
None of this is in place yet. So those are all things
Yep.
that have to be worked out for July. Right now, you're not doing anything any differently. You're seeing the turn coming down the road. You're preparing before that date comes. There's going to be plenty of technologies which we'll be able to go and get this information from. There's going to be forms that we're going to pass back. I wouldn't be surprised if Form Simplicity or Dot Loop has all these things in it that are going to facilitate the nail down of seller commissions, and we're just going to exchange the documents. Like I say, technology will fill the void, but right now you're not doing anything differently. You're just being aware. Knowledge is power. We're at 1 hour. I wanted to show you guys something, and I have no problem continuing on after this, but I just wanted to show you guys something. Can you still see my screen, Ryan?
Yep. Yep. We can
So
see
we've
it,
been
Jim.
doing title advances very successfully for a lot of agents. And people have been asking me, hey, Jim, we want to get a title commitment because we see there's title problems. We see there's issues with title. We see there's a number of things that are affecting title. So we created a couple of things at New Path Title for you guys. If you get a property that has dirty title, you can now go to New Path Title and order title products. And when you order your title products, you're going to either order your free title advance, and if the title advance comes up with open permits, code violations, or title issues, I'm going to follow up with you via text. But you can also order a title commitment or a municipal lien search, which will more specifically describe the issues that need to be fixed for closing. Those other products come at a cost. When we close, I'm going to credit you back. So if you order a title commitment because there's something confusing in the title advance and you spend the $175 or your seller spends the $175, when you close, I'm going to pay you the $175 back. If you order a title advance and it has complicated code enforcement, all the things that don't appear in the public record, if it has code violations, code enforcement, open permits, you order a PropLogic search for $270. When that thing closes, you're ordering it directly from PropLogics. The title commitment, it comes right from Attorney's Title Insurance Fund. Those things I'm going to credit you back, so you're not going to be out the money. But those are the things. I sent out a bunch of title advance summaries on Friday. One of them was for a woman new to the business. She had a property with code enforcement issues. And the seller, she didn't know any better. The seller told her, oh, we'll just pay that off at closing. Well, the sale price was $359,000, and the code enforcement issues and the liens that resulted totaled far more than, I think it was $750,000. So that thing's going to need a lien mitigation to get it sold. They absolutely want to do it. They just didn't understand the amount of time it took in the process. So the summary here is you guys are going to get free title advances. 9 times out of 10, those things are good to close on. If you see problems, you can order title commitments. You can order PropLogic searches. and we can get that stuff sorted out as to what the path to make the title and the property looks good to sell. Title commitments tell you the closing issues. Municipal lien searches tell you everything else. Everybody know the difference between the public record and the municipal record? The public record is where deeds, mortgages, judgments live. The municipal records is where code enforcement, utilities, open permits, all those things live. So they're two separate bodies, but both of them affect your closings. I just want to take that momentary digression before people started falling off. And if anybody wants to, I'm happy to go back to Sitzer Burnett and the potential settlement. Doreen, looks like you have another question. No? Oh, your hand's still probably still up from an old question. All right, if nobody has any more questions, we're at 1:06. I'd love to hear Ryan, you want to wind this thing down?
No, this has been great, Jim. I mean, obviously having an attorney perspective to this new proposal for settlement from NAR, and this is information, guys, you can't get anywhere else, right? And this is, us agents discussing, sharing information, sharing our other different perspectives of a path forward. And it's been a very great discussion, Jim. Really appreciate it. Can't say enough thanks, to you guys, to the New Path Title Leap. Can't mention the great software that Jim has developed called Title Leap. It's like a free contract coordinator. When you use New Path Title for your closings, they keep track of everything, all your drop dead dates on your contract, so you don't have to keep going back and looking when the inspection period or when the finance contingency is up. And I will give a big, huge shout out to which I use on all my deals now, is a title advance. If I'm going into a listing, I want to know if there's any issues on title that have to be addressed, prior to 14 days before closing where something pops up, right? Those can be addressed, in front, and you can take care of those. I also implore you too to check out RealTrade. We're offering some great tools here that are going to be very pertinent to this new ruling, that now that listing agents can offer buyer's agent's commission on RealTrade. So if you're a buyer's agent right here in the near future, come July, you're going to have a place where you can find out if they're offering buyer's agent's commission. So the listing agents now can advertise on RealTrade that they're offering the buyer's agent's commission. That can be simply done through a live listing update, which we've already built, that literally gets attached to the listing and that you can view it. We're going to fine tune that feature a little bit more moving forward. But
Yeah, that'd be cool, Ryan.
Yeah, the big
That's
thing
going to be huge. The ability to enter an address in 2 seconds on your mobile phone and see if they're paying cooperation commissions, cooperation compensation. That's huge. That's
and
huge.
it's like, guys, RealTrade, I wanted to make it's free for us agents, right? So it's free to create a profile. Once you create a profile, you own your listings. You're the point of contact. So if there are buyers on RealTrade too, you can get your direct leads from your listing, and then now you can communicate and get connected with all the agents on the social aspect of RealTrade. So you can send colleague requests, you can send DMs to share information. And here's the big thing, you can get connected with all the awesome service providers. So I tell everybody RealTrade's an online marketplace with a social media component, and we've merged the two. We're real estate made social, and we're literally made to help share information for properties. And that's why we developed. We want to help you get more money, get more clients, and sell properties quicker. That's our goal at RealTrade.
That's the future right there. I mean, the MLS is, I don't know if any of you guys are familiar with the medallion system in New York City. So you used to have, if you wanted to have a taxi cab in New York, you used to have to buy a medallion to be a member of the club, to lease it, to run a taxi cab. They were $1 million. Now medallion membership costs a couple $100,000, 50 to a couple $100,000, and Uber stepped in. RealTrade is the Uber of the medallion world. RealTrade is the Uber of the taxi world. No, seriously, right?
No,
There's no dues, there's no fees, and those old paradigms are falling by the wayside. And MLS, unfortunately, it's one of them.
Yeah, no, we built this. This is for agents by agents, guys. I'm an agent. I developed this, and I wanted to say this too as we move forward. If the MLSs do fracture, things happen. There could come a day, right, where us agents could actually take control of our data, own our own data, decide where that data gets distributed. And imagine this day, there could come a day where you actually get paid to list your properties, and that's
Vendors, third party, imagine that scenario, third party vendors paying listing agents for busting their butts instead of other platforms poaching agents' wallets because the whole thing is shifting.
No, the whole thing's going to shift, right? And I definitely want to stay in the forefront. I want to share this information, get that to you guys, that those things are happening. And we're going to work through this. This is just a bump in the road, but there's going to be new technology, new ways to do things. And I think honestly is going to make the industry better as we move forward. You want to wrap this up, Jim? You want to wrap this up?
This is the funnest part of my day, you guys. I thoroughly enjoy the texts you send me. I live to do this stuff. This has been the highlight of my career, is being able to be this involved with agents and keep the good stuff going. Go out and sell properties and send me your questions, and we'll make lots of great content for everybody to benefit from.
All right. Thanks, guys. Thanks for attending.